And we excuse this interruption right now. Some local district attorneys are sounding off alongside local police officers. They're concerned about the looming bail reform changes slated to take place starting next week. And right now, they're at the Staten Island DA's office where they're expected to address this new policy. We're going to take a live listen in right now.
That people in the community have. And so we are here today to echo those concerns, but also to make sure that the public is aware of these changes. And so we hope to educate and bring awareness to the sea change and provide real-world examples of how these changes will impact people's lives. And yes, again, to implore our lawmakers to revisit some of the very misguided sections of these laws and give them the careful consideration that they deserve. Also in the future here in Richmond County, we will be launching a public awareness campaign, a grassroots public awareness campaign, which we'll be announcing in the near future. And this process to revise and implement new provisions in our criminal justice statutes must include input from law enforcement. And up until now, that is not the case. We are the professionals who signed up to serve and protect the people of New York, and our perspective should not be given short shrift. I want to introduce some of the people who are with me here this morning. As I said, Jack Ryan is the acting DA from Queens. We have Paul DiGiacomo, who is the Vice President of the DEA, as well as Charlie Francis from the Lieutenants Benevolent Association. Jim Quinn is here. He's the Executive Assistant in the Queens DA. Tim Kohler is here from our office. He's our Executive ADA. Jeff Ward is from the DEA. Vincent Guida from the Sergeants Benevolent Association, as well as Jim Gatto. John Baruso, who's the 120th Precinct SBA delegate. Joe Sparacchio, who's the legislative director of the SBA. The local PBA representatives, George Winkler and Al Asierno. And Greg Silverman and Jeff Ward are also here from the DEA, and representatives from the captains as well. Did I get everybody who's here? Okay. Now, a couple issues. Let me talk specifically about where we have some issues with this package. And the first is on the issue of bail. And you'll see on either side of us a list of the some 400 penal law sections, crimes defined by the penal law, that are no longer eligible for bail. This legislation completely eliminates the ability for a judge to use his or her discretion to set bail in cases where we think it would clearly be warranted. And many of the offenses that you see listed really shock the public when we tell them, for instance, that manslaughter and criminally negligent homicide, burglary, drug sales on school grounds, arson, promoting a sexual performance by a child, assault, strangulation, aggravated assault of a child under 11. Just an example of crimes that the general public would certainly think are violent, and therefore someone who is charged with committing those crimes may well be subject to being held by bail, and that would be a way to protect society. But unfortunately, in New York, judges do not have the discretion to look at public safety when setting bail. They can only look at the risk of flight. So when people talk about the changes to the laws that were made in New Jersey, and there was no negative outcome from that, and why don't we just do that in New York, and why don't you guys in law enforcement stop complaining? Well, guess what? In New Jersey, the judges still have the right to consider public safety when determining whether or not to hold someone, to remand someone and not to give them either bail or other conditions to release them. And that's a big difference, and that's something that we don't have in the law in New York, and that's where we think that we're going to have some real serious issues going forward. Just a couple of examples. Come January 1st, a judge cannot even consider setting bail for a defendant charged with an A1 felony possession with the intent to sell. And given that we are in the midst of a terrible opioid epidemic here in Staten Island and across other parts of the city of New York, we find this shocking. Earlier this year, we arrested someone with 6 kilos of methamphetamines, as well as tens of thousands of dollars of cash, and that individual was rightfully held on bail. Come January 1st, that individual will be released, and if he had been arrested after January 1st, would have been issued a desk appearance ticket. We think that shocks the conscience, and certainly the judge in that case could not even consider risk of flight because that charge is not one of the qualified offenses. Another example is come January 1st, defendants who burglarize 4 or 5 homes are arrested for burglary 2 in a dwelling, and a judge cannot even set bail. And even though that individual may have in his or her pocket a picture of a 6th house on that block, the judge cannot hold that individual because it is not a qualified offense. It's one of those listed here, the 400 non-qualified expenses. And that's sort of the incongruity and just the lack of common sense that was included in this legislation. We consider many of these crimes heinous, and we also know that many times they are fueled by underlying conditions that will not go unaddressed, because if someone is released, we cannot try to connect that person to services, and therefore people who may be dangerous will be released. In fact, I talked about New Jersey, but in 94% of the states across the country and jurisdictions across the country, considering public safety, having that option by a judge is part of the protocol. In New York, it will not be. Also, part of this package is a discovery, changes to the discovery law. And let me just make it very simple and clear. That this is a total affront to the victims of crime. Under these new discovery statutes, we will have to, unless we get a protective order, give over the names or contact information for the victims of crime, for the witnesses of crime, and we think that this will have an incredible stifling effect on our ability to prosecute those who commit these crimes, because we will lose the cooperation of many witnesses and victims going forward. And it's so bad that in some cases the defense can make a motion, an application to do a site visit to the site of a crime, which could be an individual's home. And if you could imagine someone violated your home and committed a crime, as terrible as that may be, now their lawyers can come into your home and do a site visit. We think that that is totally outrageous. All in all, you see a pattern here of what we call lazy legislating by Albany. This package in and of itself speaks to that, but we also know pending now is a complete gutting of Section 50A of the Civil Rights Law, which gives protection to police officers' personnel files, appropriately so, and another provision that would allow anyone who's being held in prison who turns 55 years old, irrespective of the crime, that they would automatically be eligible for a parole hearing. We think that these provisions are equally outrageous and need to be carefully considered and have the right type of legislative process that people think happens. Albany wants to foist on the members excuse me, of law enforcement transparency and openness, and yet it seems that in the dark of night, as I said, these laws are being passed, and to the very negative effect of those who we have all sworn to protect and serve. So it's my privilege and honor now to introduce my colleague from the County of Queens. He is the acting district attorney in Queens, Mr. John Ryan.
Thank you, Mike. I thank District Attorney McMahon for hosting this event, and I welcome and thank the representatives of the police of this city. It is the police that are out there day and night protecting us, and they have a reason to believe that they should protect us for a reason and that the law will act appropriately. I'm going to, do we have that map to put up? You've seen the 4 charts list all the crimes that we've thus far identified that would not be eligible for bail. By not eligible for bail, we mean the defendants would have to be released. We did a map of Queens to show the current defendants that are in Rikers that we believe will be released under the new law and where they committed their crimes. And you will see first that the majority of those are felonies, not misdemeanors. And the 212 defendants involved committed a total of 293 crimes. So this is what we're up against. My purpose in being here today is I believe the public has to be educated as to what the law is going to do. If they agree with it, fine, but they should at least know what the law is going to do. I know, but I will not name members of the legislature that voted for this and did not know what they voted for and came and asked us questions afterwards. As D.A. McMahon has indicated, this package was rammed into a budget bill, and in a budget bill, you vote up or down. So there's a million things in it. This has, quite frankly, little to do with the budget, in part because the state did not fund any of these efforts. So how they could put it in the budget bill, I don't know. You be the judge. If a defendant came before you with an average of 7 prior felony arrests, 7 prior misdemeanor arrests, 2 prior felony convictions, and 7 prior misdemeanor convictions, and 3 prior failures to appear in court. Should you have at least the discretion to set bail? If you thought you should be able to set bail or consider bail or even remand, as of January 1st, judges will not even have the option for defendants charged with residential burglaries and robberies aided by another, both of which are classified under the law as violent felonies. All but one of the most serious narcotics felonies, most nonviolent felonies, including second-degree manslaughter and other crimes you may consider violent, and most misdemeanors. It's not just about individuals charged with new crimes after January 1st. When we last reviewed the numbers under the new laws, on January 1st, 212 Queens defendants currently being held on bail will walk out. These are the numbers just for Queens. Judge Lippman, who headed the commission that called for the closing of Rikers, he predicted in an op-ed article that these legislative reforms would result in the release of more than 40% of the defendants held in pretrial detention in New York City. There are currently approximately 5,000 people held in pretrial detention on Rikers. So do the math. That means about 2,000 prisoners could be released. Others, the city says the number is lower. They said it's 1,000. Either way, it's a lot. An additional 3,000 prisoners could be released statewide. The criminal resume described in my opening remarks isn't arbitrary. We looked at the 212 Queens defendants who will be released, and their average record: 7 felony arrests, 7 misdemeanor arrests, 2 felony convictions, and 7 prior misdemeanor convictions. And 81% of them are charged with felonies, not misdemeanors. Those people will walk out of jail on Rikers on January 1st. In every case, bail was set, not by a DA. DAs don't set bail. We don't have the authority to set bail. We have never set bail. In every case I described, a judge set bail. A judge looked at the defendant's background, criminal record, current charges, their history of appearance in court, and other criteria, and described in the statute, and determined that bail should be set. So what does the future hold? The last, quote, mass bailout in October 2018 resulted in just 20 Queens defendants being released on bail posted by the RFK Foundation, a not-for-profit. Of those 20, 13 of the released defendants, nearly 65%, have been rearrested for other crimes, a total of 30 times. Another 8 defendants bench warranted, 2 are still at large. A staggering 85% did exactly what was predicted when bail was set. They committed a crime or fled in just 1 year. Now extrapolate that across the 2,000 new cases. These prisoners will be indiscriminately released because the legislature refused to write a law allowing judges to consider public safety when setting bail. 47 states and the federal government give judges that flexibility, but not New York. These bail changes were buried, as I said, were buried in the budget bill. Most New Yorkers were and still are unaware of them. There is still time for the legislature to correct it. It does not have to be all or nothing. The legislature could have created categories of presumptive release and restored to judges discretion to set bail. They could allow judges to consider the defendant's danger to the public. At one point, Mayor de Blasio, then Council Speaker Melissa Mark Federico, and even Judge Lippman called for dangerous to be considered. That did not go into the law. Without any reforms to these reforms, we will start to see the results of this new legislation in New York. If the results of the Kennedy human rights experiment are any indication, New Yorkers should prepare themselves for literally thousands of criminals back in their community. I will leave you with one case. It is not a hypothetical. It's a pending case. Weeks ago, a defendant was arrested for 6 home burglaries. His criminal history: 5 burglary convictions, 4 separate robbery convictions. Under the law, he's a mandatory persistent violent offender. He was facing life in prison. A judge reviewed his new cases, his past, and held him on bail. Under the new law, if he was still not convicted by January 1st, he would walk across the bridge from Rikers Island, and he would not walk alone. Fortunately, we managed to get him to plead guilty prior to January 1st, and he's now facing a sentence of 12 to life. Just another note, just a few days ago, a defendant was arrested on a commercial burglary. It was his 44th arrest. He has 25 misdemeanor convictions, 5 felony convictions, and 14 failures to appear in court. He also has convictions in both New Jersey and Pennsylvania. Bail was set, but if his case is not disposed of, he will walk out of Rikers on January 1st. And the point is, you may think maybe he should walk out, but under the law, the judge has no choice. That defendant will walk out because the law will mandate and say to the judge, you can't do anything. So, as we've said, the legislature should review this. The public should know what the law is. And if they agree with it, fine, but they should know what it is. I thank you for your time.
Thank you, Jack. And I'm just going to ask Paul DiGiacomo, the Vice President of the DEA, to say a few words on behalf of the representatives of law enforcement who are here today.
Good morning. I just want to say to the New York State lawmakers regarding this legislation, what happened to common sense? This doesn't make common sense. There's going to be offenders that are going to go back out on the street and victimize people again. And they're going to victimize people violently. We have to do what we have to do to stop this legislation from moving forward and happening on January 1st. And these lawmakers have an obligation not only to the people of this state and this city, but to the law enforcement officers that put their life on the line every day to protect us. It doesn't make sense. Reconsider it, fix it, let's get it done. Thank you.
Thank you, Paul. Any questions? Yes.
For Queens Acting DA Brian, your successor, the district attorney-elect, is taking a different position than you in coming in opposition to Cashwell and all the cases. I'm just wondering what you make of that, and how you sort of see the approach of the office changing in a couple of months when the position
Well, District Attorney-elect Katz and I have a very good personal relationship. We both agreed that there's only one district attorney at a time, and at this point, I'm the district attorney. I'm sure she will follow her conscience on January 1st and follow her rules. I know she has talked about cash bail. She hasn't talked about this particular law, to my knowledge. Also, the law would still allow remand. I mean, if I understood her objections to cash bail, she doesn't think people should be held just for economic reasons. There is a remedy to that, in that if you think a person really shouldn't be out, you could ask for remand. So exactly how she's going to interpret the new law, I'm not sure. It will be her decision, and she will start to exercise those duties on January 1st.
Yes. Any other questions? Yes.
What are your thoughts on the supervised release option? I know that's being expanded next month.
Yeah. We've had some success here in Staten Island with supervised release, but it is a limited resource. And there is talk about expanding the availability of it, and it has proven pretty successful in appropriate cases. And in the cases that it has been used, we think it can be very effective. It is a very good tool for judges to use in cases when appropriate. But again, in many cases, the judges have lost that discretion. So we hope that the city will provide us with more funds to expand it, and there have been very positive talks about that. I will say that for our colleagues across the rest of the state who do not have the ability to go to the City of New York to expand their programs, the state legislature gave them a mandate and absolutely no funding for it. So you're going to see across the state of New York some serious implications from the fact that people think that there's supervised release options, but there are not. So, but here in Staten Island, we're fortunate and we've had success with it.
Let me ask you, how do you feel about the idea of incentivizing people to show up for court by giving them Mets tickets and things like that?
Let me, I hate to answer a question with a question, but a rhetorical question is, if I were a victim of crime and someone seriously assaulted me, sexually violated me, strangled me, and I then heard that that person who's been charged with that crime was being given Mets tickets or tickets to Broadway, or that's probably next, or other incentives, I would be outraged. And as someone who fights every day for the rights of victims, I find that to be both outrageous and pretty idiotic. Okay, one more question, anybody? John?
The victims, when it comes to the discovery, how do you feel that they might be re-victimized if, as you point out, this attorney is going to come walking into their home looking to see the crime scene?
Yeah, I think that, you try to walk in the shoes of someone else and put yourself in the place of a victim in that situation. And I think it would be totally outrageous, and it would really make someone feel violated for a second time, especially, that crime happened in someone's home. You feel that someone entered your home, that you feel violated in that case in any event. And then to have people come and trample through your homes, and, do I have pictures of my loved ones on the mantelpiece? Do I have to remove them because I don't want pictures showing who my children are and other connections? It's really a serious, serious violation of someone's privacy and the rights of victims. And that's the thing about this package from Albany. It doesn't mention victims anywhere. There are no resources for victims. There are no rights for victims. It's all about those who are accused of crimes and pushed by those who represent them. And so I think they would feel terrible, and we are very concerned that it would sort of take away the incentive for cooperating with us, because they would say, you know what, I've suffered enough. I don't want to suffer anymore. I'll just move on with my life, and people will get away with terrible crimes. Okay, everybody. Yes, yes.
So Mark Fonte, a Staten Island lawyer, said that Staten Islanders have nothing to fear from the new bail reform laws and the release of these nonviolent offenders from Rikers Island. And he said, I urge our law enforcement and district attorneys to use caution in their language and not spread unwarranted fear among residents of the borough. Do you feel like the fear is unwarranted for
No, obviously, we would not, people who work as professionals, there's probably 300 years of experience in law enforcement standing here before you, all feel that warnings to the public, explanations to the public, and advocacy to change some of these laws are warranted, because we think that crime will go up, violence will go up, and my other rebuttal would be anyone who looks at these 400 charges can see that there are crimes that an average person would consider violent. And just because they're not defined as violent in the penal law, where that definition is very specific to have subsequent cases charged higher, may be violent. So if someone strangled me, I would consider that violent. If someone burgled my home, I would consider that a violent act as well. Those are not considered under the law. So I think the jury in this case, if you will, is the public, and we want them to have all the facts. Let them make up their mind, and hopefully they will join us in advocating for changes in this law. Last one, yes, Ms.
My earlier question about supervised release, if the law is not changed by January 1st, or perhaps it is in effect for some time, do you see supervised release or expanding it even more being part of a better solution?
Absolutely. Listen, we are professionals in law enforcement, and whatever the law is, we are going to make it work to the best of our ability. The law talks about not only supervised release, but bracelets, ankle bracelets, and other means of non-monetary, least restrictive means of getting someone to return to court. It's not available everywhere, and not everyone will have that option. So yes, in many cases, supervised release is a good option. In some of the cases we've talked about, and especially the cases that Acting DA Ryan highlighted, maybe some people are beyond the benefit of supervised release, and we have to think about how best we protect society. So we're open to it. We need more resources to do it. And at the same time, we will make work what we have to make work, but we think we're in for some very dire times. Okay, everybody, thank you very much for coming. We appreciate it.